Tomorrow, the Fifth Circuit is going to hear a case that challenges the NFA and suppressor restrictions as a violation of the Second Amendment. So let's break down what is happening in this critical case tomorrow. Now, really quick before we jump into this video, I'm gonna ask you guys for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support this channel for free, please consider subscribing, and then also click the notification bell and turn on all notifications, because that helps you actually ensure that you get these videos when I release them. I also want to apologize for my voice. I'm a little bit under the weather because, of course, during Thanksgiving, it was around family and someone got me sick. But like I mentioned in the intro, in this video, we're going to be discussing a challenge that's currently in front of the Fifth Circuit Court of Appeals, and that's happening tomorrow. This case deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be talking about is U.S. versus Peterson, and this case involves an individual who had a gun store that was raided by the ATF. During this raid, the ATF found a single solvent trap that was not registered or serialized. And because of that one item, Mr. Peterson was charged with violating the NFA and was charged criminally. Mr. Peterson and his attorneys tried to get that charge thrown out by using a motion to dismiss, and they essentially argued that the NFA is unconstitutional because it violates the Second Amendment. So they brought a pure challenge to the NFA using the Second Amendment. The district court denied that motion, finding that the silencers are not bearable arms protected by the Second Amendment. That decision by the district court is now set to be heard and argued in front of the Fifth Circuit Court of Appeals, and that's happening tomorrow morning. That means that a pure Second Amendment challenge to the NFA as it applies to suppressors will be heard in front of the Fifth Circuit tomorrow morning. This case and decision has serious implications for the NFA and suppressor restrictions and could impact a ton of other cases and a ton of other issues going forward. So we need to talk about what is happening in this case. So the facts surrounding this case are very interesting. According to Mr. Peterson, on June 29th, 2022, both federal and state law enforcement officers executed warrants at his home in Louisiana. The local sheriff executed a search warrant at his home and also an arrest warrant based on him not paying some required taxes. A federal task force, which included ATF agents, also executed a search warrant based on some violations of federal firearms laws. Mr. Peterson acknowledged that he did receive a delinquent tax notice, which is in regards to the non-payment of the taxes, but he claims that he gave it to his bookkeeper and that she did not pay it and it was more of a clerical error. Now, the federal search warrant was based on issues with Mr. Peterson's operation of a gun store out of his own home. Specifically, the ATF alleges that there were straw purchases, improper record keeping when it came to 4473s, a failure to complete and forward multiple firearms purchase forms to the federal agencies, and then issues related to some products that were sold at his store and then them showing up at crime scenes. The ATF in their brief alleges that ATF agents and local law enforcement purchased various firearms from Mr. Peterson and that during those transactions, the proper paperwork was not filed. The ATF also claims that they traced around 70 firearms that were sold by Mr. Peterson, which were then recovered at crime scenes. Now, during the raid, federal agents seized his entire inventory, which totaled about 300 firearms, his own personal firearms, and then they collected a bunch of electronics from him, his children, and essentially all the electronics within his home. But here's the crux of this issue. During the search in the raid, the ATF found what they deemed to be an unlicensed suppressor. They found a single solvent trap, which was inside his personal safe in his bedroom. On October 20th, 2022, he was indicted by a grand jury and charged with violating the NFA because he knowingly received a firearm not registered to him under the NFA. Now, in response to this charge, Mr. Peterson, through his attorneys, filed a motion to dismiss that charge based on the Second Amendment. On August 21st, 2024, the court denied his motion to dismiss the indictment, and on August 29th, 2024, he entered a conditional plea reserving the right to have the Fifth Circuit Court of Appeals review that denial of his motion to dismiss of that indictment. On January 9th, 2024, the district court sentenced Mr. Peterson as a result of the charge, and now Mr. Peterson appealed the case up to the Fifth Circuit for review. The question the Fifth Circuit is set to decide is whether the district court erred in finding that the silencers are not bearable arms covered by the Second Amendment, or even if so, whether George Peterson's indictment for possessing an unregistered silencer violated the Second Amendment. So again, this is a pure Second Amendment challenge to the NFA itself as it applies to suppressors. Now, I do want to state that when you look at the arguments presented by Mr. Peterson's counsel, there is no mention of the recent Supreme Court decision, which is the Bruen case. In Bruen, you all know that the precedent set when it comes to Second Amendment cases and review is text as informed by relevant history and tradition. Instead, it seems like in this case, Mr. Peterson's representatives used what is an old standard. They used means and scrutiny. They used tiered-based scrutiny, and they argued that these types of restrictions do not meet the heightened scrutiny. They don't meet strict scrutiny. But again, that whole analysis was the old analysis. That was the old debate as regards to how do you look at Second Amendment cases. Now, text, history, and tradition is the appropriate analysis, but you don't see that mentioned in Mr. Peterson's papers. His counsel did not raise those concerns, but the ATF's brief actually does address that. Interestingly, the ATF does argue their case and their position in light of Bruen and calls out Mr. Peterson's counsel for not citing to Bruen appropriately. In the ATF's brief, they first argue that suppressors are not arms protected by the text of the Second Amendment. They claim that they are not bearable items, that they are not weapons that shoot a projectile, and at best, the ATF claims they are simply accessories, but as accessories, they are not protected. Then they argue that even if they are deemed to be arms under the text of the Second Amendment, they are dangerous and unusual items that can be regulated however the ATF essentially wants. The ATF's last argument for the constitutionality of the NFA's restrictions on these types of items, these suppressors, is that even if the items are protected by the Second Amendment, the right is not burdened by a registration process to possess those items. The ATF claims that the NFA process is a shall issue permit scheme and therefore permissible under Bruen. What the ATF is mentioning here is that under some of the dicta in Bruen, Justice Kavanaugh mentioned that shall issue CCW permit schemes may be permissible under the Second Amendment, but now the ATF is taking that language and arguing that the NFA registration process itself, that whole scheme, is similar to a shall issue scheme and therefore also permissible under Bruen. In many ways, the arguments made by the ATF in this case are recycled from the Paxson versus Dettelbach case, again, which dealt with the text suppressor issue. In contrast, Mr. Peterson's attorneys argue that the NFA does violate the Second Amendment and that it would not pass means and scrutiny. Again, I want to mention that that whole argument is framed in the incorrect way. It should be framed under the Bruen analysis, but they're using the old standard. Mr. Peterson's attorneys argue to the Fifth Circuit that the defendant's motion to dismiss must be considered in the context that the indictment charged him with, which is knowingly received and possessed a firearm. Paradoxically, now the government argues that the device for which he was charged and that he received and possessed in violation of federal law is in fact not a firearm. So again, they're talking out of both sides of their mouth. The ATF is saying we can charge him for illegally possessing a firearm. We can, charge him for possessing an arm. But when it comes to looking at the Second Amendment analysis, these types of items are not arms and they're not protected. Now, in this case, Mr. Peterson and his attorneys filed the appeal to the Fifth Circuit and they filed their opening brief. And then the ATF responded with their response brief. And then essentially, Mr. Peterson's attorneys, I believe, were set to file their reply. But no reply brief was filed, so they did not file a reply brief. And now this case has been set for oral arguments. And now all of this is coming to a head because oral arguments are happening in front of the Fifth Circuit tomorrow morning. It will be interesting to see how the Fifth Circuit 3-judge panel here treats this case and what questions they're going to ask of Mr. Peterson's attorney, and then also the ATF and the federal government. Now, the 3 judges sitting on this panel are Chief Judge Jennifer Walker Elrod, who is a Bush appointee, Patrick E. Higginbottom, who is a Reagan appointee, and then Leslie Southwick, who is a Bush appointee. I'm not familiar with any of these judges. I do not recall them being on any prior to cases that I've read out of the Fifth Circuit or any of the ATF overreach cases. So it's going to be interesting to see how this plays out. If you're interested, typically you can listen to the oral arguments live. The Fifth Circuit usually will have a live link through their website. And then sometimes they also have a YouTube channel where they will do live oral arguments as well. I will try to leave a link to the live oral arguments down below in the pinned comment once that goes live tomorrow morning, if it's available. It should be available. So if you want to listen to that, check tomorrow morning at the pinned comment on this video. So if you want to listen to the oral arguments. So again, really important case. We're going to see how this plays out. Very interesting case, and one of the first times I've seen a pure Second Amendment challenge to the NFA itself as it applies to suppressors actually being heard and argued in a Circuit Court of Appeals. So if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.